He is facing 2 counts of murder for count 2 and count 49, which each carries a sentence of life imprisonment. He's also charged with count 50 of this indictment, Your Honor, which is participation in criminal street gang activity, which carries a sentence of 5 to 20 years. He's also charged with count 51, participation in criminal street gang activity, also a sentence of 5 to 20 years. Count 52, possession of a firearm by a convicted felon previously convicted under 111-133, which is 15 years consecutive to any count in the indictment. 54, possession of a firearm during the commission of a felony, which is 5 years to serve consecutive. Count 64, which is another possession of a firearm by a convicted felon under 16111-133, which is also 15 years to serve consecutive. So Mr. Stillwell's looking at maximum of 2 life sentences plus
85 years.
Plus 85 years, Your Honor. The state's recommendation, and I'll just say globally, Your Honor, was 60 years to serve 40 years in prison. That we would have reduced both of the murders to voluntary manslaughter, Your Honor. And we had given his attorney the option to kind of craft how that 40 years would look. But that was the extent to our negotiations, Your Honor.
And Mr. Stillwell, kind of the same information to you. If the state does not want to reduce charges, you're not entitled to plead to reduce charges. They can say, you got to face these murder charges and we're going to make it a jury trial if you don't agree to what we're offering. Same thing, you can't say, well, I'd like those other charges dismissed if they're not willing to dismiss them in exchange for the negotiated sentence. So obviously each of you has the right to continue with the trial. You know, what you're doing, you are all have very capable attorneys representing you who clearly care very passionately about you all personally, as well as presenting your best case. But it's ultimately going to be up to the jury, and you cannot know what any jury is going to do. And they may say, I don't believe a single bit of this beyond a reasonable doubt. Y'all are both walking. They may say, you know what, I buy this, I don't buy that. I'm convicting you of 4 of the 5 or 4 of the 8 charges. You're still then going to face sentencing. They may convict you of everything. And if you are convicted of everything, Mr. Stillwell, you're facing 2 life sentences plus 85 years on top of that, as opposed to 40 years to serve with parole as a possibility. And Mr. Kendrick, you are facing life plus, I think I added up 115 years instead of 20 to serve 15. So it's just something to think about. And I mean, it's already past 5 o'clock. So are y'all going to leave the offer open until you have withdrawn the offer before you even put it on the record to?
We communicated this to them last night, but they did not accept it. That we would have withdrawn off.
All right, well, given that the state spent the entire day negotiating Mr. Williams' plea, ultimately unsuccessfully, I don't know if either Mr. Weinstein or Mr. Sharp would have been able to negotiate with you during today.
They would have, we didn't have any communication from Mr. Weinstein or Mr. And they rejected the offer.
Okay.
I did have communication with Mr. Abate today. I attempted to have communications with the DA last Tuesday morning, but she failed to show up for our meeting.
Any chance y'all might leave it open until 9 o'clock tomorrow?
Your Honor, I'll consult with the DA and if she wishes to read.
Okay. I mean, I have no idea whether they'd want to keep it, but I haven't, we haven't put it on the record, and I haven't ensured myself as the court that they understood what the potential sentences were up until just now. So I would appreciate it if she would, so that they have the opportunity, having heard from the court, to talk to their attorney. And they may still say that we're good, we're going forward, but
We'll consult with the
All right.
district attorney, but as a. right
Okay.
now,
so in the event that it is no longer open to you or that you decide to reject it anyway, I plan to start the trial again Monday morning. I'm going to have the jury be here at 9. I'm going to have us be here at 8:30. We're back to getting no sleep. So I'll see y'all at 8:30 regardless. Okay, now court is adjourned.
Thank you.